Today we're going to talk about the Child Status Protection Act, which we abbreviate as CISPA, and we're going to the Supreme Court. First time I'll be there. And I know we've had a couple other videos about CISPA, and I need to explain our Supreme Court case, but let me just backtrack for a couple of minutes and give you the basics of CISPA. The CISPA provides that if you're applying for one of your kids, and the kid is under 21 when you apply for him, you're a U.S. citizen, and you have an unmarried child under 21, his age is frozen at that moment. So no matter how long it takes the government to give him a green card, his age stays at 20 or 19, whatever it is, forever. And equally, if you're applying for somebody as a son or daughter of a permanent resident, you haven't naturalized yet, and then you naturalize before the child turns 21, the age is also frozen. And then the third time this happens is if you're applying as a citizen for a married child, and before the child turns 21, the child gets divorced, then the age freezes in as of the date of divorce. One small thing that's not in the law that I did want to mention that's not on our other videos is if the child is under the first preference category as an unmarried adult son or daughter, and the child already has, if the child is an immediate relative, but they have a son or daughter, so it would be your grandson or daughter, immigration will automatically flip that child to the first preference category, and they'll be able to immigrate then instead of as an immediate relative. Now, here's the biggest rule, what CISPA is all about. If you apply for your son or daughter on a certain date, that date is called their priority date. You're going to be submitting a visa petition or a form I-130, and then at some time in the future, that I-130 is going to get approved. It might be a week, it might be a month, it might be a year. And the way CISPA works is that processing time is subtracted from the child's age. So if you apply for the child and he's 20 years old, and it takes the Immigration Service 2 years to go ahead and approve the petition, those 2 years are subtracted from the child's age, so the child becomes 20. That's the child's CISPA age. And at that point, the child has 1 year to seek to acquire, to take some positive step to become a permanent resident of the United States. And what our lawsuit's about is one sentence that says, what happens if after you do the subtraction, the kid's age is over 21? That's called the automatic conversion clause. And strangely enough, the Immigration Service, which has a host of memos explaining every little part of this page-and-a-half law, all these years has never put out a memo about what the automatic conversion clause looks like and what it means, or hasn't put out a single regulation about CISPA. So the conversion clause contains all these mystery words. What is retention? What is the original priority date? What is the appropriate category? And what is automatic conversion? And the first time that the government ever decided to actually give us a clue, after the law was passed in 2002, was in 2006, when a woman named Maria Garcia was going to be deported in Mexico. And she, once you took away, her aunt had applied for her mother, and she was a teenager, and this thing went on and on and on until she was over 21. And then when she was 32 years old, the government denied her application and tried to deport her. And the judge said, well, you're out of luck. She argued this automatic conversion clause, but nobody had ever explained it. And the judge, in a case called judge was overruled by the Board of Immigration Appeals in a unanimous but non-precedent decision. Means it only applied to Maria Garcia, and later there was another case of Elizabeth Garcia, but it wasn't a rule that everybody else could use. There was no precedent decision. So we would apply after 2006 and argue that these kids who had turned over 21 could still immigrate together or shortly after their parents under the automatic conversion clause. And immigration would say, good try, but you're denied, or they wouldn't say anything. So we gathered a whole bunch of these people together, plaintiffs, and sued in federal court, and several other lawyers did that in 2008. The government, really interestingly, kept saying, well, let's not have the arguments before the federal district court judge because the Board of Immigration Appeals has this case, matter of Wang, and the decision is imminent. So they kept stalling and stalling and stalling. And then finally, matter of Wang was issued right after the judge said, no more stalling. We really need to hear the oral arguments. So in June 2009, the judge, the Board of Immigration Appeals said, look, the only thing that the automatic conversion clause or even CISPA is doing, it's making up for the government's administrative delays. Nothing to do with the visa bulletin and the waits that can go for decades, just the waits for an I-130 or an I-140 being denied or being held up for a long time. And they said in these words, the words I pointed out to you on just a couple minutes ago, like retention, automatic conversion, they pointed to single regulations and said, well, here's a regulation that talks about automatic conversion. And with automatic conversion, you only have one petitioner. And with retention, you only have one petition. And, you know, they said that whatever those particular regulations were, which were very, very cherry-picked, there were lots of other things we had introduced that were completely ignored. That's what Congress must have meant when they used those words. So the judge, after listening to hours of our oral argument, said, you know, Mr. Shusterman, you think this is clear. I think it's really complicated. I'm going to defer to the Board of Immigration Appeals decision in matter of Wang. And he did that. And all the attorneys who were fighting these cases, we all lost our cases. And both we and one other law firm, which was doing a class action lawsuit, had our cases consolidated, put together, and we went up to the Ninth Circuit Court of Appeals to challenge this matter of Wang. We lost that case. They did defer to matter of Wang. They said, we disagree with the judge. We think Shusterman's right. It is clear, but we think that it leads to a result that's really absurd, so we're not going to overrule the judge. But at the same time, there were lawyers in other parts of the country challenging this. In New York, in the Second Circuit, the court also ruled for the government. But then in Texas, in what's supposed to be a very conservative circuit, the Fifth Circuit, they ruled for the immigrant, a Mr. Khalid, who was on the verge of being deported. And they totally agreed with matter of Garcia. So what we decided to do is in very important cases, you can go and ask for an 11-judge panel. They call it an en banc panel of the Ninth Circuit to rehear the case. And we were very thrilled. Our case did get the rehearing petition approved. I did the oral arguments with Nancy Miller from Reeves and Associates, doing the rebuttal in June 2012. The decision came out in September of 2012, and guess what? We won, but by a very close vote. It was a 6-5 vote. So ever since that time, we waited and waited and waited for the government. Are they going to go to the Supreme Court, or are they going to follow the Fifth and the Ninth Circuit courts on this? The government waited till the last possible minute and then asked for an extension to January 25th of this year, 2013. And on January 25th, they filed, it's called a petition for a writ of certiorari. And that means review by the Supreme Court. At the point that I'm making this video, which is February 2013, We have asked for some time to be able to oppose that motion, but you have to keep in mind that this might go to the Supreme Court later this year. So I want not only immigrants, but I want lawyers to be able to give certain advice to their clients. Should they go forward with this, or should they just kind of wait? And the general rule is that you should wait if you're an attorney or if you're an immigrant. Because if you are in the United States and you're out of status, let's say, and you apply for adjustment of status using our victory in the Ninth Circuit, and if it's overturned, I mean, I hope it will not be, but if it's overturned by the Supreme Court, you may find yourself under deportation proceedings. But if you're already in deportation proceedings, you might as well try because you have nothing to lose. If you have kids outside the country, you should apply to get the paperwork going, and you have nothing to lose at all. So the one thing I want to leave you with is, how do you I can't make a video every month to tell what the progress of this lawsuit is going to be, but I'm pretty fanatic about the day something happens in the lawsuit, I put up something on our website and on our social media. So here's some real good free advice from an attorney. One, subscribe, go to Shusterman.com, which is our website. Under permanent residence, which is a red menu, a white menu about 2 inches down from the top. If you put your cursor there, you'll see a menu come down and it'll say Child Status Protection Act. You can also follow us on Facebook and on Twitter. We just started a new group called the Immigration Forum on Google+. Some of the top immigration attorneys in the country and immigration judges and have already joined this group, so I encourage you to do that. And then go ahead and subscribe to our free monthly email newsletter. We'll keep you up to date. We expect the briefs to be written over the summer, and we expect to be in Washington, D.C. arguing this case either in October or November. So I always close this by wishing you luck. Wish us luck.